I suppose the first thing I'll just touch on briefly is the ancillary patents, that is the superfluous patents that you have lying around. As I said earlier, if you do have a patent portfolio, it is important to review it from time to time, see what you use, see what's core to your business, and if you have some there that aren't core to your business, see if you can find out if there's anybody else who might be interested in them. Obviously, one thing you can do is you can sell the patents straight out to somebody else and then they're gone, or alternatively, you may consider licensing them. And I suppose licensing is key to all of this in some shape or form in the context of open innovation, because all of the other examples I gave there, the university looking for somebody to take its invention to the next stage, the business looking to collaborate with the university, licensing comes into all of this. And I suppose there's lots of buzzwords that are used in the context of licensing, most of which have no legal meaning as such, but you'll see them quoted in papers, and I just refer to two of them there, in licensing and out licensing. I mean, out licensing is essentially where you license out your technology or your inventions to somebody else. In licensing is where you take licenses into you. Now, the licence agreement, every licence agreement varies because they're all obviously unique to the circumstances that you have before you. That being said, there's obviously certain key elements that you'd expect to see in any particular licence agreement. And I'm just going to touch on some of those because they're probably key to the licensing relationship, and they are probably things that also need to be negotiated from a commercial point of view, as well as somebody like me addressing them from a legal point of view. And the first thing, I suppose, is what is the cost of the licence? In other words, is the licence going to be royalty free, which it probably isn't going to be if you're in an open innovation model, and if it isn't going to be royalty free, how is the payment or the royalty calculated, and what is the mechanism that may be set out? And it's important that that's clear in the licence agreement. The second thing, which sounds obvious, but I've seen many licence agreements where it isn't clear, is what exactly is being licensed. And I think it's important that the licence agreement be very clear on that particular point. Is it, for example, just the right to exploit a particular patent, or does it extend beyond that? For example, do you have a trademark that goes with the patent? Is there copyright in additional materials? So it is important that that's sort of well thought out. The third point there, termination, that's really key from a legal perspective in the sense of what is the term of the licence? Is it meant to be indefinitely? If it's indefinite, under what circumstances can the parties get out of the agreement? Let's say, for example, you license your invention to somebody, but they're not doing anything with it, hence you're not perhaps getting any royalties. So it is important to think, what are the circumstances where you would no longer like to be in business with this particular person or entity? The fourth item which an agreement should address is whether the licence is exclusive or non-exclusive. Obviously, if it's non-exclusive, it means that you can license the same technology or invention, essentially the same subject matter, to somebody else. You can have circumstances, even if you grant an exclusive licence to somebody, where there may be circumstances where it becomes non-exclusive. Normally that's where either the licensee is in breach of the agreement or they're not exploiting it to whatever level you may have agreed with them. And the other thing I think that should be very clear in a licence agreement is what are the territories covered. We mentioned there that IP rights are territorial. So if you have a patent, for example, you may have a patent in a number of jurisdictions. Are you giving them the right to exploit the patent everywhere where it's registered, or are you just giving it to that entity in Ireland and the UK, for example, and you want to be able to license it to perhaps somebody else in continental Europe? So these are the practical things that you need to think about in a licensing arrangement so that they can be reflected from the legal point of view. Some other issues to be considered, and again, it's I suppose sort of more buzzwords that one hears a lot. Patent pools. What is a patent pool? It's usually a collection of patents that have been brought together, normally from a number of different sources. and they may be the patents that you need, for example, to produce a particular product. And I suppose the advantage of patent pools from the point of view of the licensee is the licensee gets a one-stop shop. So, in other words, all the licensors have come together. They've recognised that if they come together, they have a combined thing which may be attractive to licensees, and then the licensee can get them all as part of this patent pool. Another thing that you may find is you may frequently have cross-licenses. Often businesses, or indeed you could find businesses and universities coming together where A has one lot of patents, some of which may be of use to B, B has another portfolio of patents, and essentially they share them out and there's a cross-licensing. So you can obviously deal with both in the one licence. One other thing to bear in mind is in certain industries, and this happens a lot in the technology area, you end up having what are called patent thickets, because you have a lot of patents, all of which are sort of somewhat close to each other. Nobody actually wants to take the initiative and start suing somebody else because they know they probably have a patent that's quite close to something else that entity has, so they don't want to bring the whole house of cards coming down. So you may find that there's cooperation amongst the parties, which involves essentially coexistence, I suppose, and agreements not to assert their rights against each other, so that each entity can coexist. But I suppose for that to work, you need both parties to feel equally vulnerable with each other. But you do find those sort of arrangements being put in place. And again, I suppose the other thing then to bear in mind is if the open innovation or the collaboration together results in a new lot of IP being formed, it is very important that you address who's going to have the ownership of that. Is it going to be shared? Is it going to be owned by one party? Is it going to be owned by one party with the other party having a license, maybe royalty free? So these are all issues that should be addressed at the very start, so that they don't become trouble later on. I suppose some examples from the international world that perhaps could be seen as examples of innovation and perhaps people coming together that might be a bit surprising. I did mention earlier about Apple and the whole growth in this new industry of creating apps. And obviously, Apple, to give them credit, came up with the iPhone and the iPad. But one could argue that the success of those products has been down to the variety of apps that are available. And most of those apps are created by third parties. So I suppose it's open innovation in a slightly different way. Also, if you look at Facebook, Facebook is highly dependent on a number of third-party app developers as well, because it has companies like Zynga, which makes its highly popular games, and so it's heavily reliant on its cooperation with organisations like that. And I suppose Facebook is somewhat unusual in the sense that it has embraced, I suppose, what we would call open innovation by our definition, but it's also gone down the traditional route in that it's acquired a number of niche businesses itself to try and, I suppose, address the areas where it's perceived as having deficiencies, and that's really in relation to its mobile market, where it's perceived as weak. And it has, last year it acquired a company called Relatron, and this year it acquired another company called Lightbox in an attempt to address that. There was also, I suppose, a cooperation last year between Nokia and Microsoft. So, that's the level as well where you get open innovation, even at that level, where it was with a view to using Nokia hardware running Microsoft operating systems. So you can get this open innovation at all levels. Now, infringement, and I suppose the bad news before the good news. The bad news is that if you are in business and you have IP, there's probably a very good chance at some stage during the business life you will end up involved in litigation in relation to IP. The good news is that all is not lost. It doesn't mean you will lose everything just because you are so engaged. I suppose the thing that I always say to people, clients will come in to me and they're reluctant to enforce their intellectual property rights because they feel they'll end up being embroiled in expensive litigation. The problem sometimes with adopting that attitude is they could end up losing their rights. So it is very important before you decide to adopt the strategy of just ignoring it that you do take advice on what the implications of doing that may be for you. And again, clients tend to panic, and they panic equally as much when they're forced to look at somebody else infringing them. It's not always when they get the threatening letter from somebody else. But, you know, sometimes a dispute of that nature may be the first step in a process of open innovation and cooperation. It depends on how you look at it. Somebody who's infringing your rights may actually turn out to be a potential licensee if the right circumstances are there. So that's why I'm saying don't panic just because there's an infringement issue. Obviously, there is the court system, which unfortunately in Ireland is very expensive because it's very complex. But there are other mechanisms to resolve a dispute. There's arbitration and there's mediation. As I say, if you are embroiled in something, I suppose the first rule in the game is don't panic. There may actually be a solution to it. And I suppose I'll particularly focus on defences to patent infringement because, again, and there is no doubt about this, patent litigation is quite expensive. So you do get an element of panic amongst companies faced with this. But sometimes there are actually defences to patent infringement, and one of them, I suppose, is quite obvious in that for someone to be successful against you in an infringement action, it must be the case that you didn't carry out the activities with their consent, which goes to the first point there on my slide, which is it's very important to keep records of licences granted and licences received. People forget over time that they in fact have a licence from somebody to use a particular invention. Even the entity granting the licence may have forgotten. There may be a new management team in place, a new legal department, a new law firm or whatever. So do keep good and accurate records of what you've licensed in and what you've licensed out, just in case it becomes relevant at some point in the future in the context of an infringement. It may be the case as well that the patent that you're accused of infringing may no longer be a valid patent. It may not have been validly granted. So it is important before you panic that you actually investigate the basis of the rights that are being used against you. There are also some quite technical patent defences which may be relevant to you in the sense that the invention, if it was one that you were using before the patent owner registered it, and again, if you're using an invention for private or non-commercial use, you may be able to rely on that defence. But the main thing, as I say, to take from this is don't panic. There may be ways around it. Global challenges for management of intellectual property. That was one of the things that James asked me to particularly focus on. And I suppose there were a lot of obvious ones that you could point out, like, you know, the cost of patent protection, the cost of litigation. One of the more obvious ones I did point out there, which is protecting new technology. This particularly arises in the context of, say, the software business. What exactly can you get protection for? Is it just the source code, or is there any possibility of getting protection for functionality? And that's something that the courts have been looking at as recently as a few weeks ago, where they essentially decided against the protection of functionality of software. But I suppose I've gone for a problem which you may not think you have, but you could have, or you might have at some time in the future. And I suppose I've addressed it because I think it's relevant in the context of who you go into business with, and be very careful who you go into business with. Counterfeiting of products has become a huge problem in Ireland, particularly since the recession. It was always there. It's not to say that it's a completely new area of wrongdoing. But certainly, I suppose, up until about 3 or 4 years ago, I would have had a few cases per year. Now I probably have a few cases per week. So, and I think people tend to associate counterfeiting with the rip-off of luxury goods or fancy handbags or the like. It is far more extensive than that. It's everything from car parts, aeroplane parts, medical devices. I heard one example recently of blood being counterfeited. I didn't think that was possible. I heard one yesterday of chainsaws being counterfeited. So every item under the sun, if it has a buyer, there's a good chance it will be counterfeited. There are many ways this occurs. A lot of the product comes in from abroad, and that's why I say if you're in the process whereby you have outsourced your manufacturing somewhere along the line, be very careful who you've outsourced it to. We have a lot, obviously, of outsourcing to foreign parts on the other side of the world. If you do outsource, make sure that you know who you're outsourcing to. Go and visit them. Have a contract with them where you can arrive unexpectedly to do checks. Make sure you know who you're dealing with. If budgets permit, have a local person there who will, I suppose, oversee things for you. Do practical things like, if you know the components that go into making your product, do a check on what components they're ordering and make sure that that results in the amount of finished product you expect to have. Not all counterfeit arises, as we say, by the manufacturers doing the night shift. You will have people copying as well. So if you do have physical products that are capable of having some sort of authentication put into them or some sort of quirk put into them, which just makes them more difficult to copy, that can be helpful. So as I say, that probably isn't the global challenge that you expected, but in the context of the economy and the context of where we find ourselves now, it is a huge cost to the economy because counterfeiters, needless to say, do not pay tax, do not employ people under the normal obligations that any of the rest of you who use a legitimate business do. They do not provide proper health and safety, and chances are if it's products that they're counterfeiting, like pharmaceutical products, for example, they're not made of what they should be made of or in the conditions that they should be made. So I think that's a huge challenge, and I think it's going to increase. So for any of you who have businesses that result in actual products, that is something to watch out for. Final point, role of the government in all of this. Should they have a role? Absolutely yes, in my view. How can they have a role, and what can they do? I suppose coming from my perspective, the first thing that I think they should have are strong intellectual property protection. That I think is something that we're not too bad on as a country. We have a lot of recent and comprehensive legislation on the area. I suppose where we fall down is in the expensive litigation. It's fine having the rights, but if enforcing those rights become prohibitive for businesses, they're not particularly valuable. I suppose one of my particular things that I like to rant on about is the streamlining of the court procedures and doing something about that, having more specialist intellectual property judges, and particularly in the lower courts. We have a number of them in the higher courts, but that's unfortunately where more expensive litigation results. And obviously clients are more reluctant to go to courts where they may not get the specialists. So that just happens to be one of my particular hobby horses. I think the other thing the government can do, and this probably isn't something that they want to hear or feel they can do in the current climate, is to make sure that we have sufficient resources. In the context of what I was saying earlier about counterfeiting, obviously the Gardaí and Customs have a key role to play. When their resources are reduced, that obviously has an effect on enforcement. It's also important that organisations that are involved in IP protection, like the Patent Office, that they have an adequate number of staff to provide the service that they could. And finally, I suppose I'd say the economic climate, and we heard the previous speaker talk about encouraging through very many means. And I suppose one thing that I was saddened to see abolished was the various tax reliefs on patent income. Whilst the legislation did have its problems, nevertheless, I think it was a valuable incentive, particularly for small businesses in Ireland. I did have a number of clients who very much depended on that, certainly in their early stages, to get them off the ground. And I think at an appropriate time, I think it would be a good spur to innovation to have something like that reintroduced again. So I suppose to conclude, and I've gone a bit over time, my apologies. What would I like you to take from today? And I suppose I've tried to narrow it down there to a number of points. And I think the first thing, before you can engage in open innovation, is to identify your intellectual property, protect it through registration or the various other practical ways that I've outlined. Make sure that you defend it if and when anybody tries to infringe it. And I suppose I would say recognise that you may not be able to exploit your intellectual property on your own, and see that as something positive rather than a hindrance or a limitation. Be open to partnering with others and to sharing your intellectual property in that sense. Be open to taking licences from others. Don't feel you have to do everything yourself if taking licences will enhance your business. Obviously, I say all of that with the caveat to make sure that you're properly protected in any agreements you enter into with regard to sharing. But again, you don't have to do everything by yourself, and it may be easier to do it with assistance from the outside. And again, the other thing I'd say, recognise that information can be key, and that's how really you identify your potential business partners. And again, I mentioned about, I think, the unexploited source of looking at patent registers. And I suppose my final thing is beware of counterfeiting. If it hasn't hit you, it may.